Aloha, everyone. Thank you for joining me on ThinkTech Hawaii. I am your host, Chanda Park, and we are in this episode of Money Talks. Today, my guest is Amphay Champathong, who is an attorney practicing in estate planning. Today, we're going to talk about the essentials of estate planning. Welcome, Amphay. Thank you for being on the show today.
Thank you, Shonda. It's my pleasure.
So tell the viewers a little bit about yourself.
So my family, actually, we are refugees that came to Hawaii back in 1979. I grew up in Kalihi, graduated from Kalani High School, so Mighty Falcons. I went to the University of Hawaii where I got my bachelor's, my master's of social work, as well as my law degree from the Richardson Law School.
So you were a social worker.
Oh yeah, I spent about 20 something years as a social worker advocating for children that were in the foster care system. So it's a wonderful work.
And from social work, you went to law school?
The reason, which is pretty awesome, well, in my mind, it's awesome, was that I always felt, there could be more in terms of what we do for families. And it was just in alignment about the things that I were passionate about. So I did work again with families, and part of going to law school is, I believe that, knowing more, having the knowledge, having the ability makes you a better advocate, and hence why. I always tell people I'm a social worker with a law degree because it's always the idea of how do we help families.
Yes, definitely. So what made you get into estate planning?
Again, I believe like truly in the idea of liberties. I believe, that families, that all of us should control. When we talk about working hard, building a legacy for our families, that we should also now make sure that we protect that legacy. So when you look at, again, the idea of liberties is the exercise of control. And it was in alignment with that purpose. And I know, when I work with families, especially when you look at estate planning, when it's all said and done, I'm so much more happy for the family, I think, than they are, knowing that they'll have peace of mind with regards to their legacy.
Yes, definitely. Can we bring up the first slide, please? And let's expand more on the importance. Why is it important to have an estate plan, and should everyone have one?
Well, it's interesting because there's this misconception, when you talk about estate planning, people always, it's like what you see on TV. I don't know if you heard recently with, Britney Spears, Lisa Marie Presley, and, all these different um, celebrities, right? And they go, oh, they're fighting over the estates, hundred millions of dollars, and then and I think it plays to this sense that it's only for the ultra rich. And to me, I think it's actually so much more important for the modest families. I think everyone should look at estate planning. Now, there are going to be things that happen within our lives that's going to require, someone to intervene on our behalf to make sure that our children are taken care of, make sure that our assets, our savings, and like I mentioned earlier, the legacy that we want to leave goes to the people that we want it to go to. So, I think everybody needs to look at getting their estate plans done.
And when you compare that, you just said you feel it's more so for the modest family versus the celebrities. And it's because of the cost, right, to the individual after. Like the celebrities already has the money. But like you said, for the average person, you want to have all of that left for your loved ones.
Well, it's a matter of simple math if you think about it, right?
Yes.
Because regardless of how much you are going to be, the cost for the court proceedings and all the fighting and the appointments, all those things that are associated when we don't have our estate plans are going to be the same, whether you're ultra rich or you have a modest, assets. Think about it, right? If it's going to cost, 50, 60, $70,000 to now do probates, which we will talk a little bit, what happens, right? If you have an estate that's worth 100 millions, what is, 60, $70,000 to 100 million estate? Now, when you think about modest families that have, $100, $200,000 in retirement, or you talk about one property, their family home, okay, taking, 60, 70, $100,000 from that just for the court proceedings, that's like a huge chunk of what could have been used rather than to go through the legal process that can be used by the family. So you can see, right, like it just is so much more costly to our families. So.
Right, versus just investing a small amount to make sure that you have everything in place. So go over some of the math.
So let's kind of go over some simple terms that I am going to be referring to throughout our talk this afternoon, and just give you some definitions, right? So the first term that I want to talk about is called probate. Okay, so probate is a court proceeding where the court will appoint someone called a personal representative to administer your estate upon your death. Sounds simple, yet hopefully we'll talk a little bit more about that. Okay. Incapacity. Okay. Incapacity is the inability to make decisions either because you are mentally or physically incapacitated, or because you're a minor under the age of 18, because the law considers all minors to be incapacitated. Lastly, conservatorship. Okay. So conservatorship is a court proceeding where the courts will appoint someone called a conservator to gain access of your things, to manage it for you because you've been now deemed incapacitated. And this conservator would act, okay, for your benefit. Now, with regards to the court proceedings with probate and conservatorship, there are all going to be potential costs if you don't get your estate plans done. I see some numbers there with regards to probate. To open up probate, it's about $6,000 to $8,000, and that's being fairly conservative. Okay, and then when you look at conservatorship, to open up a conservatorship is $5,000 to $8,000. And if you see the number behind underneath there, okay, for every single year that you've been deemed incapacitated, okay, there has to be now annual reviews, okay, of your estate. So basically, you can see we talked a little bit about minors being deemed incapacitated. Okay, you think about this with regards to the cost. Say you had a 10-year-old and you pass away. Okay, and they have to now open up probate. Okay, so first you have to pay the cost to probate. Okay, once it's been assets are now probated, okay, then you will need to open up a conservatorship. So that's an additional, okay, $6,000. And then let's say at the age of 10, okay, for every single year, we have to file with the courts for an annual review of the estate. So now for every single year, and 10 until the child becomes 18. At that point, that's 8 years. Times that by, let's go simple math, 5,000, that's 40,000. And then to open the conservatorship, that's another 6,000. You're essentially using up $46,000 conservatively. Okay. Now, just to make sure that the needs of this child is being met. So as you can see, it's very costly.
Yeah, it's by the time the child is then 18, a lot of his or her assets has been drained because of that. So let's talk about no estate planning, and let's bring up the next slide.
So again, if you do not have your estate plan, if you die without a properly designated and funded estate plan, your estate may go through probate. Next slide. And these are some of the drawbacks when the estate is now in probate. Okay, it becomes a public process, and then you will lose privacy. Okay, so what that means is the general public can go to court and get information with regards to what is going on with your family. They can figure out, who you owe money to, who's going to get what. A probate is very expensive, as I mentioned earlier. Okay, it costs about $6,000 to $8,000 to administer or a simple probate. Okay. It's also time consuming. A simple probate takes on average 8 months to a year. Okay, and that's actually being very, with the time, and it actually could even take longer. The law also requires that when you open up a probate proceeding, that there is notification made to family members, not only family members, but extended family members, to creditors, to general public. So this idea of an invitation to a fight. Everyone is given notice of the date and time, and then now, your family members, creditors, public, whatever else can come at that time and stake an interest or objections towards your estate.
Yeah. So, I mean, people can relate it to celebrities because, they're well known. The information is just spread all over. And just two on the top of my head that I can remember that did not have estate plans were Prince and Aretha Franklin. And I know that there are so many more. So, what are your thoughts on that?
Expensive. No, it's just it's amazing.
Millions of dollars, right?
And you know what? I did read up on Prince, just for, like I said, I find it amazing, like the things, and the people that were coming out and those that were just fighting for. And it's sad because like in these situations, well, in my experience, families don't ever are never the same again.
Mhm.
And for that loved one that passed away, I don't think they ever intended, that their children, and their grandchildren, their siblings, that the families will be forever broken. So it's really, really, like I said, sad to say, sad to see. Excuse me. Okay. So other drawbacks, okay, is that now, law will decide. Okay, so I had shared this with you in terms of like why I'm passionate about this work in estate planning. It's really to go, the idea of control. Like Liberty says, we get to exercise control of the things that we work hard for. And then if you don't put your estate plan in order, okay, the law will decide for you. Okay? And the law now would make assumptions as to what it thinks that you wanted it to happen with regards to your estate. And sometimes the law does get it right. Okay? Most time it doesn't. I'll give you an example. So if you have just what used to be historically a nuclear family, meaning husband, wife, and then they have children together. If you pass away without an estate plan, okay, the law says in that situation that okay, what's in my estate will go to my wife and then to my children, right? Very simple. As you know, or as we all know now, there.
There's many blended families.
Oh yeah, well, more than half of marriages end in divorce, and of course there's remarriages. And I just as a side note, I looked this up, and they said the second marriages end in divorce for almost 75% of those marriages, and then when you get married the third time, anyhow. Okay, so in this example for our blended families, okay, the law may not do what it is that you wanted it to do. I'll give you an example. Say you have a husband and wife, and the husband now has a child from a previous relationship. So what happens there is when you pass away, when husband passes away, okay, the first 100,000 will go to his spouse, the wife, okay, and the remaining assets now will be split equally between the child of the other relationship and his wife. Okay. Usually, the biggest assets that we have is going to be the home that we live in. Yeah. So now in this scenario that I gave you, let's say the house is worth $1 million. Okay. So husband passes away. This house is in his estate. Then now what happens is wife will get the first 100,000. Okay. The remaining 900,000 will be split between wife and the child from the previous relationship. Okay. So now the child from the previous relationship has the right to go with regards to this estate as the beneficiary. I'm entitled to $450,000. You can see now, and if this child from the other relationship demands that, right, what kind of issues you're going to run into? Because I don't think too much of us have $450,000 sitting around somewhere where we can actually now.
The other person.
Right. So.
Okay, so those are some of the things that can happen if you don't have an estate plan.
Well, there's more. Actually, there's a lot more, but let me go over one more thing before. Okay. Again, like the idea of loss of control. Okay. Another drawback, which I think families need to know about, is the idea of outright distribution. Okay. So if you don't have your estate plan in place, when now the courts decide and name a personal representative for you, this personal representative, again, will pay all the taxes, pay all the expenses. Whatever is remaining now, the law requires that this distribution goes outright to your beneficiaries. Okay? The problems with that is, as you know, in the slide says, there are things that are going on that may be going on in the life of your beneficiaries at that time. Okay? In that whatever they're getting is going to be subject to their life situation. So if they're getting a divorce, they're getting sued by creditors, they get into an accident, they owe people money, all of those things will be subject to, whatever it is that you're leaving to them, it will be an outright distribution, okay, and will be subject to that. The two problems is this. First, we don't know when we're going to pass away. And secondly, we don't know what position our beneficiaries are going to be at that time. The last thing I want to say too is when you look at outright distribution, so our firm have this thing called a baboos beneficiary. You know what a baboos is, right?
You can explain it.
It is like what it says, baboos. Like you don't know what the heck you're doing. So imagine, okay, you turn 18 years old and then you inherit all of this money, a couple $100,000. At 18 years old, if I didn't have any, I'm going to speak for myself. I know exactly what I would have done, which at 18, without any financial education, not knowing and coming into a whole lot of money, I'm going to waste it.
Yes.
So with this outright distributions, you can see now and I don't think, the intentions of, right, the person building their legacy would want it to be just wasted. Okay. And that's what usually happens.
Yeah, that's true. So when you have your estate plan, you can basically, you're saying you're in control. So you can write everything that you want, when you want distribution, the amount that you want. You're in control of everything when you have that written down.
Yep. And that's the whole, we go back to the idea of liberties. Next slide, please.
So in talking about conservatorship and guardianship, I know that there's a story, right? And everyone knows basically who Britney Spears is. So can you explain a little bit more about what that situation was about? So
let me go back to the definition of a conservator, and then I'll talk more about Britney Spears. That's amazing story in itself. Right? So if you become incapacitated without a proper estate plan, okay, a conservatorship and guardianship may have to be established to manage your property and make decisions regarding your personal affairs. Next slide. Okay. So here are some of the drawbacks, and then it really relates to Britney Spears. Okay, so the two things people fight about, okay, when you go to court, which can be very, very costly, is first, okay, whether you're incapacitated. So Britney Spears, for almost 15 years, right? Her dad says, oh, she's not fit to handle her financial affairs. She's not, and imagine that. Okay. And don't quote me. I'm just what I hear. I've not verified this stuff, but my understanding was when she was performing at Planet Hollywood, and it was like over like she was earning like 100 something million there. She was getting an allowance in the thousands. Think about that. And this was going on for 15 years. Okay. The other thing that people fight about is, well, of course, first, okay, whether or not you're incapacitated. And then now, if you don't have it in your estate plan, what usually happens is somebody else will decide. And when I say somebody else, what that usually means is you get two doctors, right? A doctor to decide. And usually you can have one expert say one thing, and you can get any doctor to say the opposite thing. And now you have two experts saying two conflicting things, and somebody else will decide. Okay. The second issue is that
even more time and money.
Yeah, taking a lot more time and a lot more money. The second thing is who's going to control, okay, all of the funds, and people fight about that as well. And something closer to us here in Hawaii, as you I think many people know about Princess Kallander. She recently passed away, and I don't know if you knew, but that court proceedings with regards to the conservatorship has been going on for the last, it was like 7 years possibly, costing over $7 million just to litigate about now whether or not she's incapacitated and who's going to be her conservator. So
that's a lot of money.
Yeah. Next slide, please. So as I shared with you, right, there's a lot of drawbacks, when we don't plan and we don't take the time to do our estate planning. And I'm hopeful, Chanda, that you invite me back, and the next time I can talk more about what is a proper estate planning. Okay, and I want to share this definition. So when you look at estate planning, okay, the idea comes back to control. I want to control my things while I'm alive and well. I want to plan for me and my loved ones. Okay, if I become disabled, I want to give, okay, what I give to who I want to give when I want to give. Okay, I want to protect my assets from creditors and predators. And lastly, right, as what we spent the earlier part of today's conversation is, I want to keep it out of, okay, court proceedings, which again takes a lot of time. Okay, costs a lot of money.
Okay. Yeah. So what does estate planning entail? Bring up the next slide, please.
So at a proper estate plan, of course, we will elaborate on this in the future. But essentially, if you are looking at what is a proper estate plan, it would entail having these following documents. It would a revocable living trust, a certificate of trust, a pour-over will, a durable power of attorney, an advanced healthcare directive, HIPAA and HIPAA authorization. And now, if your plan is missing any of these documents, you're going to have a puka in your planning. And the idea again of having all of these documents in a proper estate plan is to foremost avoid all of the things that we talked about that involves the court proceedings. Okay. And then now keeping it private to you and your family.
Mm-hmm. And without education, having someone speak about this, I notice a lot of times people think that having a will is enough. So can you just quickly explain before we end the difference between a will and a trust in terms of proper estate planning?
So it's funny you say that, because usually when you have conversation with families and you say, oh, do you have your estate plan? They'll tell you, yeah, I do. And then when you ask a couple more questions, they say, oh, well, I have a will.
Mm-hmm.
And there's this a will in itself, okay, is not sufficient. It is one of the many documents that I have elaborated on before. Okay. Now, with a will, there are certain things your will can do that a trust cannot do. However, a will in itself, again, is not enough. So 2 points that I wanted to make with regards to wills. The first thing is, for a will to become effective, you have to die. Okay? What happens when you're incapacitated and now decisions have to be made, access to your funds have to be, to meet your needs? A will does not come into play until you pass away. The second thing is, okay, a will still needs to be probated. So when you pass away and you just have a will, that will would be needed to go to probate court. And then, of course, we talked about the whole thing with, your privacy, it being a publican. So all those things now come back to play.
I see. I know there's so much more to talk about. It's it's a wide range, right, of things that you talk about with conservatorship, guardianship, advanced healthcare directives, power of attorney, and all of that. So I would love to have you back on the next episode of Money Talks so that we can go over more of estate planning. And I talk about 0 to millions with building a strong financial foundation. Proper protection helps protect assets, and so does estate planning to assure that you leave a legacy. So I want to thank you for being on the show today to explain about estate planning. If you have any questions, here is Amphay's contact information. You can reach out, and he will be on the next episode of Money Talks. So we will see you then. Aloha.
Thank you. Aloha.
Thank you so much for watching ThinkTech Hawaii. If you like what we do, please like us and click the subscribe button on YouTube and the follow button on Vimeo. You can also follow us on Facebook, Instagram, and LinkedIn, and donate to us at thinktechhawaii.com. Mahalo.